All
So
right.
we shouldn't wait. We just we should get going.
Yes, I just started the recording. So I
Mhm.
will, good evening, everyone. Ahmed, Kimberly, thank you for joining us live. This is the March 29th session of the ABA Legal Education Police Practices Consortium Fellowship meeting. I wanted to reiterate something I sent in an email earlier today, that if you are unable to make a meeting, please let me know in anticipation, either by RSVPing appropriately to the calendar invite or by sending me a follow-up email to let me know what your intentions to attend. It is a challenge when we have limited folks in the Zoom room, and I would like to be able to anticipate that to the best of my ability. So please, going forward, if you are unable to attend, please send me a note so that we can plan accordingly. But today I am delighted to be joined by Christopher Slobogin from Vanderbilt University Law School. Throughout this semester, we've been talking about policing technologies, and throughout that conversation, has become clear that at every step of the way, as technology around policing has grown, the need for data retention and understanding where and how the data that is collected is stored and then used is a growing and very important issue. And so, because this was so relevant to our field of study and something that I was quite interested in what the legal precedent around was, I wanted to reach out to one of the leading scholars on this topic to give us more information. And so I was grateful that Chris agreed to speak with us, because he has authored more than 100 articles, books, and chapters on topics relating to criminal law and procedure, mental health law, and evidence. He was named director of Vanderbilt Law School's criminal justice program in 2009 and is one of the 5 most cited criminal law and procedure law professors in the country over the past 5 years. He has served as a reporter for 3 American Bar Association task forces on law enforcement and technology, the insanity defense, and mental disability and the death penalty, and as chair of both the ABA's task force charged with revising the criminal justice mental health standards and the ABA's Florida assessment team for the death penalty moratorium implementation project. He's currently an associate reporter for the American Law Institute's Principles of Police Investigation Project, and is a good friend and active contributor to past research of the consortium. So, Chris, thank you so much for being with us today. I look forward to hearing from you and hand the floor over.
Great, thanks, Justin. Yeah, so I thought I would talk about my book since I know it pretty well. It was published, as you can see, back in 2022, and it tries to address how we should regulate what I call virtual searches. So where did I come up with this phrase, virtual searches? It's to distinguish what police are often doing today from what they used to do traditionally. In the old days, police would engage in physical searches. They go through someone's house, someone's car, file cabinet, that kind of thing. But these days, they're just as likely to stay in their office or in their squad car and carry out their investigations that way. And that's why I call what I'm talking about virtual searches. This is going on a lot more than it used to. Is this the kind that you've talked about in other sessions, or is this relatively different from what you've talked about?
This is pretty consistent with what we've talked about, although we've talked more about the types of technology that is used, and
Okay.
so the storage component is new to us.
Yeah, so I'll be talking about types of technology, but then I'll also be talking about ways we can regulate it, specifically through the Fourth Amendment and statutes. And you probably talked about that as well. So some of this may overlap with what you've talked about before. But yeah, I'll be talking about a number of different kinds of technologies, ranging from CCTV and automated license plate readers to facial recognition technology and data mining and various other kinds of technologies that police are using today. And basically, these developments have taken the courts sort of by surprise. I mean, they're not really ready yet to regulate. And maybe that's a good thing, because perhaps we need to have a lot more of this happening and for things to percolate in the lower courts before the higher courts say anything definitive. But precisely because this technology is starting to be used quite a bit, and because the courts haven't quite figured out what to do, I thought it was the perfect time to write a book about how they might regulate this kind of police investigation. So let me just give you an example of the kinds of things police do. Let's say it's the year 2025. Officer Jones stops a car for a traffic violation. Obviously, this is the kind of thing that happens every day, right? Police do it thousands of times a day. It turns out the person that is stopped this time is an individual named Mohammed Salshin. He was violating a traffic law, but his license and his driver's license and his registration check out. There's no arrestable offense. But Officer Jones is a little suspicious nonetheless. For what reason, he can't really say, but he decides to use a Raytheon electromagnetic pulse scanner, which can detect weapons and explosive devices through opaque surfaces. So he scans Mohammed's car with this device. Nothing comes up, nothing at all. But Jones still wants to keep track of Mohammed. So what does he do? He gets Mohammed's cell phone number, and they use that cell phone number to track the phone as it travels around New York City and its environs. And they also use CCTV cameras. Right now, New York has roughly 10,000 of these in various places in the city. They all feed into a $40 million command center. You can see part of that command center right here. And they can watch people on these screens. And of course, it's all recorded as well. They can access recordings later. So they use that also to track Mohammed. And they notice that he goes to a number of different mosques in the New York City area. So they decided to get even more information about him. They decided to get his financial records and his communication records. They want to get information about who he's sending money to, who he's getting money from, and they want to see who's communicating with. They want to see the phone numbers and the email addresses that he's communicating with. And for good measure, they contact a data broker. And I've just got the logo for ChoicePoint here. There are a lot of different data brokers. We'll talk about more of them later. But this is one, sells a lot of information to the government. And they get information about Mohammed from ChoicePoint. And then finally, just to cap it all off, they rent an apartment across the way from Mohammed's apartment, and they set up a Startron, which is basically a telescope with heat sensing, thermal imaging capacity, so they can see what's going on in Mohammed's apartment, at least when the curtains are open. So that's a lot. It's possible to find out Mohammed's involved with some kind of terrorist activity. It's possible to find out he's undocumented. It's very likely that he's totally innocent of anything. But the important point I want to make is that right now, none of this is regulated by the Constitution. Nothing I've just described is regulated by the Constitution, which to me is pretty stunning. You all know, you've talked about the Fourth Amendment, right? You all know about the Fourth Amendment. I don't need to go in detail about that, but just to remind you, it prohibits unreasonable searches and seizures. It requires warrants in non-exigent circumstances that have to be based on probable cause, found by a judge. If you had to quantify probable cause, it's a more likely than not standard, or maybe something a little bit less than that. There was an interesting study, a poll of federal judges. They were asked to quantify probable cause, and on average, they said about 48% certainty, for what it's worth. You've also heard of reasonable suspicion, right? That is a lower standard of certainty than probable cause. It authorizes not full searches, but does authorize a frisk. Doesn't authorize a full arrest, but it does authorize a stop. And if you had to quantify reasonable suspicion, it might be about a 30% probability. And in fact, the judges the judicial survey I mentioned earlier, it averaged out to about 28%. So those percentages are just heuristics. I wouldn't bet that any court's going to adopt those statistics, but it gives you an idea of the relationship between probable cause and reasonable suspicion and what we're aiming for when we're trying to come up with the standards that the Fourth Amendment recognizes, the Supreme Court case law recognizes. So that's what the Fourth Amendment says, if it applies. But as you know, the Fourth Amendment only applies when the police action's a search, right? You all have talked about that, right? It only applies when police action's a search. And you all know this, but when I tell my students for the first time this, and when I tell lay people this, they're amazed at how few things are searches. And in fact, there are 4 different doctrines the Supreme Court's developed that make it clear that a whole bunch of what police do are not searches, especially if they're virtual searches. So, first doctrine, well, first of all, I'm going to just say this. I know you know this already, but as you know, back in '67, the court decided Katz, which held that a search is not what a layperson would say, that is, looking for something or examining something. It's when the police action infringes an expectation of privacy society is prepared to recognize as reasonable. You all know that, right? You've talked about that, right? Okay, but there are 4 doctrines that the court has developed that interpret this language in a very restrictive way. It is clearly a search if what happens in Katz happens, which is they bug a phone. That violates reasonable expectations of privacy. But if instead what the police are doing is accessing information that's knowingly exposed to the public, it's no search. Why? The court says you don't have a reasonable expectation of privacy. You knowingly expose to the public. So what does that mean in Muhammad's case? GPS tracking, not a search. Why? So long as it's tracking what you do in public. If it tracks you inside your house, different story. But so long as it tracks you in public, no problem. Automated license plate readers, it's all public, what they pick up. No search. CCTV, that huge data bank of TV screens you saw in Muhammad's case, no search involved there because all those cameras are aimed at public activities. You don't have any expectation of privacy in public activities. That's the knowing exposure doctrine. Then there's the general public use doctrine. And that's the idea that, hey, if police use technology, but it's technology that you can pick up in Walmart, not a search. You have no expectation of privacy vis-a-vis items that you can buy in Walmart. So the Startron that I talked about in Ahmad's case, which is the telescope with thermal imaging capacity and night vision capacity, you can buy that for about $1,000. A good one for $1,000. If that's not generally available to the public, nothing is. In fact, the case that announced the general public use doctrine involved a map-making camera that cost $20,000. And the court said, that's in general public use. Well, if that's in general public use, then something that costs $1,000 is in general public use. The third doctrine, contraband-specific doctrine, even if it's very sophisticated technology that costs a whole lot of money, if all it does is pick up something the court thinks has no privacy significance, then there's no search. You don't have an expectation of privacy over things you don't that have no privacy significance to them. So that Raytheon device that I talked about, that Officer Jones used in Ahmad, since all it does is pick up weapons and explosives, no search. It's just picking up contraband. Now, the picture I have here is not a contraband-specific device because obviously it's picking up more than just a gun. So that's not a contraband-specific device. But if you can develop a device that only picks up the gun, then that would be contraband-specific. Some people call this a binary search. I'll talk more about this case in a second, but it developed in the Place case where the police use a drug-sniffing dog. So once again, if you can develop a contraband-specific device, no search. So all 3 of those doctrines cut a pretty big hole out of Katz, right? It's a lot of police activity. It's only if public travels that uses technologies in general public use. It's contraband specific. But those 3 doctrines combined don't come close to exempting from Fourth Amendment protection what the 4th doctrine does. I call it the assumption of risk doctrine. Some people call it the third-party doctrine. You talked about this one too, right? You talked about this? Basically, the court said in a number of cases, hey, if you hand over information to a third party, you assume the rest of the third party will turn around and give it to the government. The court said that in a case involving bank records. It said it in a case involving phone logs. So what does that mean? All that information, documentary information they got about Muhammad, his bank records, his phone records, not a search at all. No Fourth Amendment requirements at all. And the same thing with the choice point records. The information the data broker choice point got. Don't need any suspicion, don't need probable cause, don't need reasonable suspicion, don't need anything. That's the whole point of all of these. None of this is a search. If it's not a search, you don't need any justification. Certainly don't need a warrant. Don't even need reasonable suspicion. Now, some of you may be thinking, if you know your Fourth Amendment law, well, that doesn't sound quite right. Hasn't the court retrenched on this a little bit? And you're right, it has a little bit. But I emphasize the phrase a little bit, very little. So all of you have heard of the, can you see that? Can you see this up here? Or is it in the way? Because my screen, it's, the recording announcement is in the way, but you can see it?
We can see it, yes.
Okay, good. So in Jones versus United States, you all know that case, right? 2012. The court held that tracking a car for 28 days is a Fourth Amendment search, even though the tracking was only on public thoroughfares. However, the court had a major caveat. It's only when the GPS device is a physical one planted on the car, only if there's a trespass. So in other words, what happened with Hammond's case would not be a search. Why? They didn't plant any device on his car. They just used his GPS signals. There's no trespass involved there. So that's not a search, at least as of now, according to Supreme Court. It is true some lower courts have said that's a search, but as of right now, Supreme Court has yet to say whether that's a search. Now, there are 5 justices who are willing to say that's a search, at least if it's prolonged. And apparently they thought the 28-day tracking in Jones was prolonged. Okay, so maybe we have 5 justices. I say maybe because actually we've changed some justices since, we've changed a whole bunch of justices in 2012. So who knows? What's the law? What would be the law if they get a case involving tracking without a trespass? In any event, it would have to be prolonged. So what if it's 2 days of tracking? Who knows? So that's why I say small cracks in the jurisprudence, little changes, not big ones. Everybody thinks Jones is a big case. It's not a big case. If I'm a prosecutor, a state's attorney, I have lots of ways of limiting Jones, big ways of limiting Jones. Got to be a trespass, and if it's a trespass, it's got to be prolonged tracking, or it's not a search. We also have a case that appears to limit to some extent the contraband specific doctrine, because in Jardine, the court said, hey, a dog sniffing a house, even though all it sniffs is the odor of drugs, and that's contraband, it's still a search if it's of a house. But what if it's of a car? What if it's of a person? Don't know. Then we get this big case, and it is a big one. I don't want to minimize it too much. You all have heard of Carpenter, right? You've talked about Carpenter? Yes, no?
We have not.
Oh,
The
okay.
students may have learned about it through their other
Yeah,
classes.
maybe if you've taken criminal procedure, you've talked about this case. Obviously, a pretty recent case. This is a really interesting case. There have been a series of bank robberies. Police weren't sure who did it. They thought maybe Carpenter was involved, but they weren't sure. They got a hold of his phone without a warrant. They got a hold of his phone. And sure enough, his phone had been near 4 of the banks that were robbed at the time the banks were robbed. Well, that's pretty good circumstantial evidence that Carpenter has something to do with the bank robbery. You might be near one of the 4 banks, but near 4 banks that were robbed at precisely the time they were robbed, that gave them probable cause to go after Carpenter. But even though they got 7 days of cell site location information to find that out, they didn't have a warrant. And to some people's surprise, Supreme Court held they should have gotten a warrant. Now, what do you think the prosecution argued in this case? Well, they argued, hey, third-party doctrine. You gave up that location information to your common carrier, to Verizon, to whoever your common carrier is. You assume the risk that third party will turn around and give it to the government. That's a solid argument. At the time Carpenter was decided, lower courts had routinely said, cell site location information, don't need a warrant. Third-party doctrine. Miller and Smith, the 2 cases involving bank and phone records. But in Carpenter, a majority, actually a very slim majority, basically 5 justices, said, no, that is a search. Why? All of a sudden, were they changing their minds? Well, they finally got some common sense knocked into them. They said, contrary to what they'd said previously, that you don't really voluntarily and knowingly surrender information to a third party thinking the government's going to pick it up without a warrant, right? You can't live in modern society without using a cell phone these days. So to say it's voluntary when you surrender your cell site location information to Verizon, whoever, that's a legal fiction. That's not right. And I think the court's right about that. It's hard to say that's truly voluntary. You can't live in modern society without using a bank, without using a phone. And by the way, third-party doctrine also applied to medical records. Hey, you gave that information to a doctor, you assume the rest of the doctor will turn around and give it to the government. I think the court's starting to realize, ooh, this third-party doctrine can go too far. So in Carpenter, they said, we're no longer going to buy into this voluntary thing. They also said, I think this is actually the more important part of the decision, another reason to hold that you need a warrant for cell site location information is the amount of information they got. They got 7 days of cell site location information. That's a hell of a lot more information they got in Miller, where they basically got a few bank records, and Smith, where they got one phone number. And the reason that's important as a justification is that when you think about it, if this is the justification, if the justification is you don't really voluntarily surrender information to third parties, then the court should have overturned Miller and Smith too, right? Because your bank records are not really voluntarily surrendered either. You got to use a bank in order to live. You got to use a phone and to call people, or you can't really exist in modern society. So if this is the rationale, the court's got to overturn Miller and Smith. But they specifically said in Carpenter, we're not overturning Miller and Smith. Our decision is limited to its facts. You've heard that before, right? You're law students. You've heard that over and over again, Supreme Court. Our decision is limited to its facts. Meaning what? You need a warrant for cell site location information. You don't need a warrant for bank records. You don't need a warrant for phone logs, for the numbers people have called. It continued to adhere to Miller and Smith. So again, I'll reiterate what I just said. So that means this really can't be the rationale for Carpenter, right? It can't be, oh, it's not really voluntary when you surrender information to third party, because then they'd have to overturn Miller and Smith. The real difference is what they did in Carpenter was they obtained a lot more information about Carpenter than they did about Miller and they did about Smith. Okay? And that's going to be important for what I say later. So where are we right now? It's not clear. As I say here, there are some cracks in the jurisprudence, but if I'm a state's attorney, I still got a lot of arguments to make to the effect that various kinds of virtual searches are not searches. Unless there's a trespass, unless it's a contraband-specific search of a house, unless you get a whole lot of information about from a cell site location, common carrier, it's not a search. That, as far as Supreme Court's concerned, that's the law. Now, it is true, lower courts are taking the Jones case and the Dean's case and the Carpenter case, and some of them are running with it. Some of them are expanding, which is, that's what you do sometimes. But if you're a careful lower court, you don't really have much to work with. So things are up in the air, is my basic point. Jones and Carpenter in particular are useful to defense attorneys, useful to defendants who want to expand Fourth Amendment coverage, but it's not exactly clear how far it should be expanding. So that's why I wrote my book, going back to my first slide. That's why I wrote a book called Virtual Searches. We need to figure out what we should do in this situation. And basically, my first move is one that a lot of people have suggested. We should define the word search in the Fourth Amendment the way everybody defines it in the real world. It's looking for something. It's examining something. It's looking through something. Even Justice Scalia says this. He's no longer with us, but he says in the Kylo case, which we'll talk about more maybe later, he said, hey, search should be defined, Webster's Dictionary defined it. I don't know if you know this, but Scalia loved Webster's Dictionary. Okay, the 18th century version of Webster. Well, actually the 19th century, early 19th century version of Webster. He used it all the time because, he was originalist. He thought, hey, we should go with words. We should define words in the Constitution the way they were defined at the time the Constitution was drafted. He said the way search was defined the way at the time the Constitution was drafted, it means looking for something, examining something, looking through something. So I go with that. A lot of other people have argued that that's not new. That's old. And I think actually that can be consistent with cats. I think you could say that anytime the police are looking through anything, they are infringing on expectations of privacy. Because, and I'll get to this more later, if you ask the average person, even when they're walking on the street, they feel like they have anonymity, right? They feel like they have some privacy. I mean, they might say, yeah, if I see a cop looking at me, I know at that moment I don't have much privacy, but as a general matter, when I'm walking along the street, I don't think people or cops are following me visually or otherwise. And in fact, I assume they're not doing that. I assume I have anonymity in public. And I have done some survey research that verifies that. I'll talk more about that in a second. But the basic idea is the first move is search means looking for something, examining something. The key, where the rubber hits the road, is what to do if something is a search, how to regulate it. That's really the most important thing right now. I think that's what the court's going to have to deal with. It's going to slowly but surely expand the definition of search. But then it's going to have to figure out, okay, what happens next? Now, what usually happens if something's a search, if you've taken criminal procedure, you know this, what usually happens is the police have to have probable cause. But a lot of lower courts have started to realize, well, if that's the case, we're in big trouble. Because a lot of these searches are designed to get probable cause, right? It's basically a catch-22. You call something a search, you need probable cause, but you can't do it because you don't have probable cause to do it. You need to do a lot of searches to get probable cause. So what I argue, and I argue in detail in the book, I'm not going to do that here today. I'll just give you a brief sketch. We ought to think about how to regulate searches in the 5 different ways you see here. And I'm going to very briefly go over all 5 of these ways, and I'll probably finish in about a half hour, and then we'll have about 25 minutes for any questions. Or, as you can probably tell, I can keep on talking. But I think it would be useful, even though there are only 3 of you, to open it up for a conversation. So I'm going to talk about suspect-driven, profile-driven, event-driven, program-driven, and voluntary-driven virtual searches. I think there are 5 different varieties of virtual searches. All of them should be regulated differently. So suspect-driven, what's that? That's the Muhammad case, right? This is the traditional search. What's going on here? The police have a suspect, but they don't have probable cause to arrest. They're looking for as much information as they can to tie the suspect to the crime. So I have a mod up here. I changed his name to Muhammad because we got a mod here on the Zoom, and I figured we didn't want to identify the mod as the suspect. So, but I forgot to change on the slide. Well, actually, I didn't have time to change on the slide. So let's say we're looking for information about Muhammad. We want as much information as we can get. Well, in the old days, what did they do? They went through, they might go through Muhammad's home. They might go through the file cabinet. They might go through his car. How do they do virtual searches? Well, all the ways we've been talking about. They might track them. They might get data from third parties. They might use a Raytheon magnetic pulse scanner. Lots of different ways they could do it. If you require probable cause, I've already alluded to this, if you require probable cause for those searches, I've got 2 problems with that. One is not every search is equally intrusive. I mean, I think you'd have to admit, going through a house is a lot more intrusive than watching someone on the street. Or conversely, watching someone on the street is not as intrusive as going through someone's house. And the Supreme Court has actually recognized that. Most of you, if you've taken criminal procedure, you know about Terry versus Ohio. What did the court hold in Terry? You don't need probable cause to do a stop. You only need reasonable suspicion. That's a lower level of certainty, as I pointed out earlier. How come you only need reasonable suspicion? Because a stop's not as intrusive as an arrest. A stop is a very short-term detention. It's not a full-blown arrest. The court said the same thing in the Camara case. In Camara, the court said, if you're going to do a physical inspection of the home for health and safety violations, to look at electrical wiring, plumbing, and that kind of thing, you don't need probable cause. Even though it's a house, you're only looking at electrical wiring. You're only looking at pipes. You're not going through file cabinets. You're not going through drawers. You're not going into bedrooms. So there again, the court said you need probable cause. Why? Because health and safety inspections are less intrusive than a full-blown search of a house. So the courts already recognize this idea that not all searches are equally intrusive. And they said you don't need probable cause for some kinds of searches that are not particularly intrusive. And the other reason I don't think probable cause should be required for every search, I've already mentioned. If we require probable cause for every search, police investigations would come to a screeching halt. If you need probable cause to get probable cause, you're in a catch-22 situation. And the court sort of recognized that in Terry. The court in Terry said, police need to be able to do stops based on reasonable suspicion so they can investigate a situation, and maybe nothing's going on, but maybe they'll have probable cause to arrest the guy they've stopped. But you need to be able to do the predicate stop first without having to have probable cause from the get-go. And I think the same thing is true of the kinds of virtual searches that I'm talking about. So I came up with a very simple idea. The courts ought to adopt a proportionality principle. And it's what you see here. The level of justification for a search should be roughly proportionate to the level of intrusion. That's not really new with me. As I said, I think Terry and Camara basically adopt a proportionality principle. Terry said, you don't need reasonable suspicion for a stop or a frisk, because a stop and a frisk are not as intrusive as a full-blown arrest, as a full-blown search. Jones sort of says that. Remember Jones said, prolonged searches, you need a warrant. Searches that aren't prolonged, tracking that's not prolonged, you don't need a warrant. That to me is proportionality principle. Though I would still require some justification, even for short-term tracking. I don't think you need probable cause. Carpenter says that. Carpenter said in a footnote, we're going to require a warrant for 7 days of cell site location information, but we're not saying anything about less than 7 days of cell site location information. That's the proportionality principle work. So even though I'm suggesting something that the court hasn't said explicitly, I think it permeates the court's jurisprudence. So I'm not going way out on a limb here. I think this you can find in the Supreme Court's jurisprudence. I think the major objection to the proportionality principle is not conceptual. I think conceptually it makes a lot of sense, and I think the courts recognize it. The objection is, well, how do you implement that? I mean, okay, if probable cause is required for the most intrusive searches, and reasonable suspicion is required for less intrusive searches, should there be other levels of certainty too? Because certainly you can come up with more than just 2 levels of search, of intrusiveness. And how do you figure out how intrusive something is? And I admit that is an issue. It's sometimes called the administratability issue. How do you administer the proportionality principle? But I think it's possible. So first of all, Supreme Court itself has recognized a number of different types of justification. There's warrants, of course, which have to be based on probable cause. There's subpoenas, which can be based merely on a relevant showing. That's actually a showing below reasonable suspicion. There's probable cause, reasonable suspicion, and relevance. There's supervisor authorization. That is not a judge authorizing it, but some high-level officer. So there are lots of different ways we could do justification. We could do warrants. We could do a court order based on reasonable suspicion. We could do a subpoena based on relevance. We can have a supervisor authorization based on reasonable suspicion or on relevance. There are lots of ways to go here. Okay? And as I'll point out in a second, in fact, some statutes already do this kind of thing. The federal government has already done this kind of thing. And I'll give you an example in just a second. Then how do we figure out intrusiveness? I mean, I think most people would agree, search of a house is more intrusive than watching someone on the streets. But how about all the other scenarios? Well, there are lots of ways of figuring out how intrusive something is. First of all, we can look at positive law. There are statutes that can help us figure out how intrusive something is. There are statutes that make it clear that intrusion into a house is a much more significant trespass than intrusion onto someone's private land, for instance. Statutes make that distinction, okay? But statutes only provide us a little bit of help there. And what I have argued, and this is controversial, I admit, what I have argued is that we ought to look at surveys of what people think about privacy. If you remember the test for cats, the test that cats came up with, what is a search? It's expectations of privacy society is prepared to recognize as reasonable. That's a direct quote from Katz. It's expectations of privacy that society is prepared to recognize as reasonable. The Supreme Court itself used the word society in its definition of privacy. Well, that to me suggests we ought to ask society what it thinks privacy is. And I've done that for the last 20 years. I've done surveys. And by the way, since I started doing this, a lot of other people have replicated what I've done. And not surprisingly, searches of houses are much more intrusive than watching people on the streets. But also not surprisingly, but very relevant what we're talking about here, when people are asked, how intrusive do you think going through your bank records is? What do you think the result is? It's as intrusive as going into someone's bedroom. That's what my survey said. Now, that's totally contrary to what the Supreme Court said, right? If the police go into your bedroom physically, they need a warrant. If they go to your bank records, they don't need anything under the Fourth Amendment. Well, that would change under the proportionality principle. Police would need probable cause or something close to it to get bank records. They'd also need probable cause to get cell site location information, which Carpenter has said is the case, but bank records as well, not just cell site location information, and so on. I could go into detail about this. I'm not going to now. But actually, what I get in my surveys is a pretty nice hierarchy, which is pretty commonsensical. Bedroom searches, bank records up here. Surveillance of public activities way down here. A frisk up here, along with tracking for short periods of time, tracking for long periods of time up here, and so on. So what does this suggest? That intrusiveness ought to depend on where the search is. Is it of the home or is it outside the home? The type of information being obtained. If it's medical records, hey, we need a lot of justification for that. Utility records, not so much. If we're going after the content of a phone call, then yeah, we need probable cause. In fact, the Supreme Court's held that. If we're going after the metadata of a phone call, like what number you dialed, maybe we don't. Maybe we only need reasonable suspicion to get metadata of a phone call. Amount of information. If it's 28 days of tracking, like in Jones, okay, we need a warrant. 2 days of tracking? Maybe not. Maybe only reasonable suspicion. Why? Because it's less intrusive than 28 days. And notice what else it does. It allows the police to track someone for 2 days when they've just got a suspicion, which helps them develop the probable cause they'll need for a warrant if they want to keep on tracking. And as I said earlier, the federal government's recognized this kind of thing. In Title III, they require a warrant for bugging a phone, but in the Electronic Communications Privacy Act, which is what ECPA stands for, you don't need a warrant to get subscriber information or metadata. You do need a court order, but it can be based on reasonable suspicion. This is precisely what the proportionality principle would require. So that very briefly was suspect-driven regulation. And that's the most important one. But I want to talk about, like I said, now we got another 20 minutes or so. Talk about 4 other types. Everybody okay? Anybody want to ask a question? I've been talking a lot. If you want to ask a question, feel free. We can save it till the end. I don't really care. Maybe you're bored with me talking. You just want to hear yourself talk. Fine with me.
I'll ask a quick question. I
Okay.
apologize. Wind. I'm in windy Boston right now.
I see you walking around. Yeah. Mm-hmm.
Yeah. I'm sorry. I just got out of work. Going back to, you kind of set it up as a hierarchy of intrusiveness. Going back to how you kind of spelled it out.
Right.
I know recently I remember reading about a New York appellate court case that came out in December where dog searches, so dog sniffing searches, were considered, under the protections of the Fourth Amendment. So I'm curious as to what you think about that, and also how you would rank that within your list.
Well, I will tell you, that's a very interesting question. First of all, that's contrary to the Supreme Court. That's a state court decision that goes against what the Supreme Court said. That's fine. Obviously, states can provide more constitutional protection than the federal courts than the federal Constitution does. So that's, I'm not saying the state court acted illicitly. I assume they based that on their state constitution. My surveys found the dog sniffs were basically at the reasonable suspicion level. So in other words, they did find it was a search. They found it to be much more intrusive than things that clearly are not searches, like going through foliage in a public park. At the same time, they did not see it to be as intrusive as going through a house. There's another tweak to the dog search thing. You know, in order to do a dog search in the scenario you're talking about of a person, you got to stop the person. So the predicate to a dog search in that scenario is you need reasonable suspicion to stop the person. You can't just willy-nilly stop people. Now, you could just have the dog walk down the street and sniff, as like you're walking down the street right now, right? A police dog could go by you and maybe alert. That would be okay. But if the cop is stopping you so the dog can search you, that's a predicate stop that requires some kind of suspicion. And then you get to the dog search issue, which in your state now requires, apparently, at least reasonable suspicion, if not probable cause. I would only require reasonable suspicion based on my surveys, but I would require something for the search itself. So on all these videos you see of police stopping a car on the street and then having a dog come and sniff the car, can't do that unless at the time you got reasonable suspicion. So in my opinion, police are routinely violating the Fourth Amendment when they do that in connection with a traffic stop. Does that answer your question?
Thank you so much. No, this was great insight. I appreciate it.
Okay, now let's talk about what in many ways is the hot button issue these days. You've all heard of profiling, right? It's often connected with racial profiling. I'm going to talk about profiling generally, and later I'll talk about racial profiling. But police profile all the time. I mean, half of policing is profiling. They just didn't call it that. And they don't like calling it because profiling has such a dirty sense to it now. But in Terry versus Ohio, that stop and frisk case, what was the cop doing there? He's profiling. He watched, if you know the Terry case, and you may have studied it in criminal procedure, what did Officer McFadden see? He saw two guys walking up and down in front of a store 24 times, then consulting with a third party, then going off somewhere, and that's when he stopped them. He was profiling. You see, this is weird. Who would walk in front of a store window in a real estate agency office 24 times? Something's up. That fits my intuitive profile. Now, he didn't have data to back him up, so it was an intuitive profile, but this is what police do on a daily basis. So some people argue, you know what? Profiles are actually better. They're not worse. They're better. Why? If they're based on data, as opposed to intuition, they'll be more accurate than police doing seat-of-the-pants profiling, which can get them in all sorts of trouble, right? So what the police decided to do, the federal government, more specifically, they developed drug courier profiles. Now, I will say, I've looked at these. Some of them are jokes, right? They're just made up stuff. But actually, some of them are based on data, right? They look at the kinds of things that correlate with people who carry drugs through airports or courier drugs using cars. Now, their hit rate still isn't very good. You know, out of every 100 cars they stop based on the profile, only 10 of them, only 20 of them have drugs. That's not a very good hit rate. But at least they're based on some data, whereas when cops are going seat of the pants, what do they use? They use race. They use appearance. They don't use appropriate factors at all, whereas these profiles, they're not allowed to use race. They know they can't use race as a profile, so that's not one of the factors. So this is why I wanted to preface this by saying, you know, profiles, they have a dirty name, but in fact, compared to what goes on today, they in some ways could be better. I'm not saying they're great, don't get me wrong. I'm not even advocating for profiles. I'm just making the case that data-driven profiles could be better than what we've got today. But let's talk some more about this, because I end up having lots of positive profiles. Okay, I made the positive case for profiles, but that's it. From now on, I'm negative about profiles. Okay, so what kinds of profiles are the police using in terms of virtual searches? Well, some of you may have heard of Chicago's heat list. They called it the strategic subject list. So what did they do? They looked at arrest lists, arrest records, and gang lists, and they came up with so-called threat scores, or their heat list. If you had a score of 500, you were very, very, very high threat. Even a score of 200 made you high threat, high risk. Okay, and they went around stopping people and surveilling people based on this heat list. Well, eventually some private companies would get in on the act, and a company named Intrado developed this tool called Beware, which not only used public records like arrest records, and they got a hold of gang lists too from police departments. They also started looking at social media information, Instagram, that kind of stuff, and they developed threat levels: red, yellow, and green. And that was a tool that the police could use. If they came across a risky situation, they'd use a Beware tool and sometimes be able to say, oh, this guy's a red. I need to be careful around him. Or this guy's a green. Don't need to worry too much about that. This guy. So that gives you an idea of how profiling can work. And I should have prefaced this by saying these are hot people profiles. Police have used hot spot profiling for a long time. What are hot spots around town? There might be like crime. That has issues too, but it's a lot less controversial than this. This is hot people profiling. We're actually zeroing in on people based on what the profile says. And here's one that's very interesting. This is, I call it the goal tube because there's a guy named Sherrod Goal who developed this based on data from New York. And he ended up coming up with a 3-factor profile based on what you see here: sights and sounds of criminal activity, a suspicious object, and a suspicious bulge. Now, I will admit these are relatively ambiguous factors, but as we'll see, they're a lot better than some of these other profiles. And they got a pretty good hit rate here. We'll talk more about that in a second. Bottom line, what I think should happen is the proportionality principle should apply here as well. Okay, to profiles. What does that mean? First of all, we can't apply the proportionality principle unless we know what's going on. So if the profile is based on artificial intelligence, right off the bat, we got problems. Because it's not going to be transparent. If it's based on deep learning, we have no clue what's going on. And I make arguments in my book about why this is unconstitutional. I'm not going to go into them now. And then even if they're transparent, we got to make sure we know what's going on. What weights are the various risk factors given? And if we can't understand that, then they shouldn't be usable. Secondly, should not use racially biased data. Now, this is loaded, right? A lot of these profiles use arrest records. Well, we know that a lot of policing is racialized, especially drug arrests. It turns out that marijuana use and cocaine use amongst whites and black people are basically the same, but black people are arrested far more often for those kinds of crimes than whites. Why? Maybe they're arrested for something they didn't do, or maybe whites aren't arrested for something they didn't do. But in any event, there is some disparity in terms of those crimes. And so what a lot of these profiles have done, to their credit, they don't use drug arrest records anymore because they realize there's some racial disparities there. But on the other hand, other kinds of arrest records are not clearly racially disparate. In other words, racialized policing doesn't affect murder arrests, robbery arrests, sexual assault arrests, even most property crime. There doesn't seem to be much racial disparity there. But if there is, you got to worry about that. This is where the proportionality principle plays a role. What kind of data are you accessing in order to develop your profile? Up here, Chicago was just using public records. Proportionality wouldn't require much justification for that. And what would the justification consist of? What's their hit rate? How good is the hit rate? How often is a person identified as a high risk, as a high threat person based on the records? If the hit rate is not very high, it's not going to justify access to many kinds of records. But if all this being accessed is public records, maybe you don't need a very high hit rate. But on the other hand, you're accessing social media info. My surveys put social media access much higher than public records. You'd need more justification to access that information. So in other words, the Beware tool, it wouldn't even be able to operate unless they can show they have a pretty good hit rate in terms of identifying who's high risk as opposed to low risk. And the proportionality principle has another implication. You have to look at what they're using the tool to do. If they're arresting people based on the tool, they better have a really high hit rate. It better be over 50%. Remember back in my second slide when I quantified probable cause? You cannot arrest someone unless you got probable cause. Unless your profile has a hit rate of over 50%, you shouldn't be able to arrest. Well, I can tell you right now that none of these profiles have anywhere near a 50% hit rate. Okay? And to tell you the truth, given reality, they're never going to have a hit rate of 50%. Now, what if instead they just stop someone? Well, the gold tool actually had about a 35% hit rate. These other ones did not, but the gold tool did. In other words, about 35% of the people who met these three factors ended up having a gun on them. So who knows? Maybe that would be okay. But in addition, I would require, for lots of reasons I'm not going to go into now, that even if the tool has a good hit rate, you can't use it unless it's corroborated by conduct. Now, the gold tool is corroborated by conduct. Suspicious objects, suspicious bulbs, but particularly this one, sights and sounds of criminal activity. Now, granted, that's very vague. That could be a lot of different things, but at least there's some corroboration of criminal activity here. On the other hand, if you don't have this, if you don't have corroboration, think about what could happen. The police could stop anyone who, for a tool that has a sufficiently high hit rate, anytime they wanted to. Why? Because this is all static information. The arrest record always exists. The social media information's already been obtained. So they could stop Joe Blow based on arrest records and social media information, find nothing. 20 minutes later, they could stop him again. Why? Nothing has changed. Still got the arrest record, still got whatever's on social media. Stop him again 20 minutes later. You need conduct that occurs right before the stop, before you can do anything. I could say a lot more about that. I realize I've hit you with a lot of information, but I want to move on to the next category, unless someone has a question. Got about 10 more minutes before I open it up. Okay, what about event-driven virtual searches? So suspect-driven is when you got a suspect. Profile-driven, you don't have a suspect, but you got a profile of someone who might be a suspect. What's event-driven? You don't have a suspect, you don't have a profile of a suspect, you got an event. More specifically, you got a crime. You know a crime has occurred, but you have no idea who did it. Okay? So what am I talking about here? Have any of you heard of geofencing or cell tower data dumps? Let's say a murder occurs right outside my office right now. What did the police do in the old days? They go from door to door, knock on doors. Did you hear anything? Did you see anything? What do they do today? Virtual search-wise. They go to Google and find out phones that were near the scene of the crime at the time it happened. And then they narrow down the phones. Some phones maybe weren't at the scene of the crime at the time it occurred, or for some other reason clearly were not associated with the crime. They might narrow it down to 5 or 6 phones. Then they might see where those phones go to and where they came from, and narrow down the search that way. The Baltimore Air program, similar kind of thing. What Baltimore did for a while in their air program is they videoed all daytime activity using high-flying planes and recorded all of it. And if a crime occurred, oh, by the way, all that was videoed, people look like white blurry dots, and cars look like white blurry dots. So that's what the recording showed. Then if there was a murder or some other serious crime, they go to the recordings, and they trace where the dots came from and where they went to. And that way they could figure out, or possibly figure out, who was near the scene of the crime at the time it occurred. They wouldn't necessarily have the perpetrator, but they'd maybe have some eyewitnesses. Did they arrest people? No, not right off the bat. They'd investigate further. But they used the virtual search as a way of figuring out who was near the scene of the crime. I happen to think, privacy concerns aside, it's a pretty interesting way of solving crimes, right? If you have no clue who did it, who might have seen it, you might be able to use virtual searches as a way of zeroing in on perpetrators or eyewitnesses. But not surprisingly, nonetheless, there have been arguments that this should not occur because you might pick up lots of white dots, right? Lots of people might be picked up in the data dump. However, I would apply proportionality reasoning here, and I would argue that not much justification is required for this kind of virtual search. Why? All you're learning about a person through this kind of virtual search is where he or she was, where they were at a particular time and place. That's all you're finding out. It's nowhere near what happened in Jones, 28 days of tracking. It's not even 2 days of tracking. You're basically finding out about where the person was for about an hour's worth of time. And that's all. And if you want to do any further investigation, you need further suspicion to find out more information. But it is the case that these cell tower dumps do get information about lots of people. So I argue that they only should be allowed when it's a serious crime and when the geofence is limited in time and place. And I base that actually on a Supreme Court case. Some of you may know this was a case where the police set up a roadblock exactly a week after a car accident to find out, not necessarily who the perpetrator was, but maybe eyewitnesses. Because they figured, hey, the accident occurred at 4 p.m. on this stretch of road. Maybe there are people who routinely go down the stretch of road at 4 p.m. every week at the same time. So they set up the roadblock. Did they arrest people at the roadblock? No, they asked people questions. That to me is an event-driven search. They've got a crime. They know a crime occurred the week before. They're doing a crime-driven, an event-driven kind of search. And it's very narrowly tailored. Particular time, particular place. Okay? So that's my argument. Basically, it's analogous to the particularity clause of the Fourth Amendment. Some of you may know, if you know the Fourth Amendment, you know the particularity clause is the search and seizures have to be limited in terms of people and places. So that's the idea there. Okay, there are two more types of virtual searches. I'm going to go through them very quickly, but I want to do it. Actually, the next one, I'll spend some time on. The last one, I'm not going to spend much time on at all. The fourth one is what I call program-driven. What is this about? Suspect-driven, profile-driven, and event-driven virtual searches. What do you need to do them? You need data. Jesslyn mentioned this, right? You said you've talked a lot about accumulating data. Well, that's what I'm talking about now. In order to do those kind of searches, you need data. Well, where does this data come from? Where does the government get it? It gets it from two different places. It gets it from its own computers and databases, and that's the category I'm talking about now. And it gets it from private databases, which is the final category of virtual searches I'm talking about. So let's talk about government data accumulation. I call this program driven because these are government programs, right? Government programs designed to collect data for use in suspect driven, profile driven, and event driven investigations. Well, the most famous, how many have heard of the Total Information Awareness Program? It's the most famous data collection program ever. But if you haven't heard of it, obviously, what the point this makes, I think, is interesting. It means we don't have any clue what information the government's collecting. Because if you haven't heard of it, look at the name of it. Total dead ear, by the way, deaf ear with respect to PR. You don't call something total information awareness if you're the government. What a stupid name. Because that's precisely what they're doing. Look at this picture. You probably can't see everything that's going on here. But basically, they collected information from government records, communication records, medical records, veterinarian records, because you never know when a dog might have a bomb in it. And then they collected all this information, accumulated it in databases, and then they ran profiles, supposedly, to see if they could identify terrorists. And this is, I really love this part. This was the icon. This was the logo for total information awareness. Again, a total deaf ear when it comes to PR, right? It shows an all-seeing eye looking out over the globe. And this is Latin for knowledge is power. Scary as hell, right? And what's my proof that it's scary? Congress defunded the Total Information Awareness Program 2 years after it started. It was created by the Defense Department in 2001. Congress defunded it in 2003 by voice vote, Republicans as well as Democrats. They took one look at this logo and said, there's no way this is happening in the United States of America. So, scary. But guess what? You all know this because Edward Snowden's told us this. Total Information Awareness did not go away. It just came back under other names. PRISM, Stellar Wind, the NSA Metadata Program, et cetera, et cetera. It's still going on. It is more limited than it used to be, but it's still going on. Total Information Awareness was not limited at all. It was just the Defense Department doing whatever it wanted. Now we've got some limitations going through all these different data sources, but not much in the way of limitations. And that's all federal. This is state. Right here in Tennessee, we got one fusion center. And you all I know from all over the country, you've probably got a fusion center in your state. There are over 100 of these babies now. Some of them have 200 employees. What are they collecting? All sorts of information. That's why they're called fusion centers. They fuse together information
from lots of different sources. I interviewed one employee, and the quote I like best from the employee was, people would throw a fit if they knew what we were collecting. I think enough said. Okay? So, what's the regulation of these various programs? Virtually nothing. The NSA metadata program, that's where the NSA is collecting our phone numbers and email addresses, that is being regulated. Obama put in place some regulations. But the rest of this, virtually no regulation. And so what I argue in my book, there's got to be regulation. This is crazy. There's no regulation. But where does it come from? Because the Fourth Amendment doesn't really speak to this. This is data collection. It's not, the government's not looking at this yet. They're just collecting it. They might look at it later in a suspect-driven, profile-driven, or event-driven way, but they're just collecting it right now. And Fourth Amendment case law doesn't really address this issue. But what I argue is, how many of you have taken administrative law? Administrative law directly addresses this. What is administrative law about? It's about programs. It's about government programs and regulating government programs that affect the rights and obligations of citizens. And what does administrative law provide? The Federal Administrative Procedure Act and all the state Administrative Procedure Acts require several things before a program can happen. One, there needs to be an authorizing statute. Well, guess what? There's no authorizing statute for fusion centers. The federal government has appropriated money for it, but there's no statute setting out what fusion centers can do. Same thing with stellar wind. What should the statute do? It should identify, okay, what harm are we trying to go after? Terrorists? Terrorists and felonies? Terrorists, felonies, and misdemeanors? I think if Congress had to actually sit down, or any state legislature had to sit down and say, what do we want the government collecting data for? They probably wouldn't want the government collecting data about misdemeanors and misdemeanors, right? It'd probably be that kind of limitation. And what kind of means? What kind of records can the government collect? Bank records? Phone records? Common carrier records? Medical records? I think if Congress and legislatures had to think about this, they wouldn't allow this kind of stuff to happen. And in fact, there's evidence for that, because the law regulating the NSA metadata program has lots of limitations passed by Congress eventually. Okay, once they had to sit down and actually think about what they were allowed, it wasn't just the left-leaning Democrats that got in the act. There are a lot of conservative Republicans that don't like this at all. And you get a consensus on what should be allowed. But unless you have legislation, it never happens. Administrative Procedures Acts require legislation. You cannot have these programs unless there's an authorizing statute. The programs alter vires unless you have a statute. Okay? And then if you're taking administrative law, you know what else has to happen? There has to be regulations implementing the statute. There has to be notice and comment about those regulations so the public gets to weigh in on what they want. The courts can do a hard look review to make sure the regulations are rational. And this is very interesting. The regulations have to be even-handedly applied. They can't go around just collecting data about Muslims. That would be a violation of administrative. I think it's also a violation of equal protection, but the courts have been very reluctant to apply equal protection doctrine. But administrative procedure law has an embedded equal protection rule in it that programs have to be even-handedly applied or they violate the Administrative Procedure Act. So I think, for what it's worth, this is a major contribution, in my opinion, to regulation of data gathering. And then the final area is, what if it's a private company that's collecting the data? And that's like ChoiceBook. That's like these data, Axiom, Oracle, all these data brokers you've heard about. A lot of them, their business model is to collect information so they can sell it to the government. ChoicePoint exists solely to provide information to the government. Well, guess what the government's argued here? We're not collecting the information. So none of what Slobogin just said applies. It's the private companies that are collecting it, and we're just buying it from them. And in fact, they make arguments like, hey, these data brokers, they got a First Amendment right to collect information and sell it to whoever they want, and they got an autonomy interest. I think that's balderdash. I think the data brokers are basically state actors. they're basically, especially if their business model involves selling information to the government, they are a state actor that ought to be regulated in the same way a government data collection program is regulated. I'm not going to go into all the stuff you see here. I'm basically saying they've got a fiduciary duty to all of us. And what I argue is that companies like Palantir and ChoicePoint, these other data brokers, they should be governed by the same program-driven rules that I talked about here. There's got to be an authorizing statute. There's got to be notice and comment. And if Palantir doesn't like that, then stop selling information to the government. You can collect it for your own ends. If you want to have some kind of private business that uses all this data, fine. But you cannot sell to the government unless there's an authorizing statute, subject to notice and comment, et cetera, et cetera. And I'm just going to leave it at that. Be glad to talk about the rest of this, but I said I'd stop about 10 after, and it's a little after 10 after. So that's it. If you got any questions or comments, feel free. I can also keep on talking. Whatever you think, Jessalyn, whatever you want to do.
I thought that was just brilliant. Thank you so much for providing us.
Well, if you thought I was brilliant, then you know what to do. Buy the book.
Like and subscribe.
Isn't that a cool? I like that cover. I've done a lot of books. This is the best cover I've ever had.
That is a great cover, very snazzy. But what I really liked, Chris, about your presentation is I think it built really well upon a presentation we had earlier this semester. I'm pulling up my calendar now. Yes, it was early February when we had Andrew Ferguson from American University.
Well, Andrew and I agree on a lot, but we don't agree on everything. He definitely does not like what I say about event-driven. Because what he said, oh, you're collecting all this information on all these people. I said, Andrew, so what? So they know you were near my office for a half hour one day. Yes, that is a search. I agree with you, it is a search, but it's not very much information. And basically, Andrew would say, you can't do this at all, which I think this can be a very effective investigative technique. If you were here right now, he'd have some definite rebuttal. But my argument is in part, a lot of this is very useful to law enforcement. I don't think we should, oh, it violates privacy, therefore we should never do it. I think that's an overreaction to use of technology. I think it should be, some of it should not be allowed, and all of it should be regulated. But a lot of what I see from Andrew and other people, we shouldn't do it. It just should not happen. And I think that's an overreaction, because I think some of this technology can be very useful to law enforcement. And it can be, and especially when you think, criminals are starting to use technology a lot too. And it's sort of an arms race. We need to allow government to use technology if criminals are using it. So I'm glad you mentioned Andrew. And again, I think he's great. I cite him a lot in my book, by the way. I think he's got some really good stuff. So.
Yeah, and I love the ability for us to bring complementary, while not necessarily the same viewpoints to this conversation. I think that's really valuable.
Yeah, we'll get Warren Kerr to come, and he'll disagree with both me and Andrew. Warren Kerr at Berkeley.
Ahmed, Alex, Kimberly, what are your thoughts, questions, comments, reflections?
I guess I can kind of take a swing at it. I hate that I missed the first part of this presentation, but I was gulping up what you were putting out of that fire hose. It was a lot of information, but I enjoyed every part of the presentation. I thought it was fantastic. I guess my first question kind of goes to the latter data collection points that you had mentioned. And you talked about the APA and as administrative law and how there are safeguards as long as they're authorizing legislation. I guess my question, to get a little bit more focused, revolves around the court currently, not necessarily around Fourth Amendment law, but the court currently putting kind of more clamps onto administrative law in general, administrative regulations. Okay.
Really good. That's it.
Sorry, I just had a graphic pop up on my screen, but my question is, does that help kind of where this is going? Is the court putting clamps on this mean good things for how data is used nationwide?
That is a very insightful point. I've given this kind of talk to law professors, and no one's ever said that. And I think that's a very good point.
so where I thought you were going, I'm going to start with where I thought you were going first, and then I'll get to your point. A lot of people say, oh, and Ferguson would say this, I don't trust legislatures, right? I mean, they're beholden to law enforcement, right? Law enforcement has more power than any other interest group. And so they're going to get what they want. And yeah, you're going to require legislation, but the FBI is going to write that legislation and they'll be able to collect them. Well, it turns out that's not true. If you look at what's happened with the few situations where there has been legislation, there's been an amazing amount of regulation going all the way back to the 60s when Congress actually is focused on something. As I said before, Republicans as well as Democrats can get behind some pretty significant regulation. And in addition, remember, at least if the APA applies, which I think it should, you got notice and comment where the public can weigh in. You got to have rational rules. If you've taken administrative law, you know what a hard look review is. Courts can't overturn regulation necessarily, but they can say, this regulation is not rational. It's sort of rational basis with bite, to use equal protection here. Okay, that's where I thought you were going. And I wanted to get that in, even though that's not where you were going. Your point is that this court seems to be willing to have not dismantled, at least significantly reduced the scope of the administrative state. And I know a lot of people are scared about that. I mean, if you're thinking the FDA or the Environmental Protection Agency, you're scared. Ooh, well, what's going to happen to all that? I mean, we're going to have polluted air and drugs that aren't safe. First of all, I don't think the court's going to go there. I think, for instance, the recent abortion drug case, they're not going to go there, okay? But at the same time, I think you're absolutely right. I think the court is going to move in the direction of putting some restrictions on the administrative state. And one thing they're definitely going to do, in my opinion, is rejuvenate the non-delegation doctrine. They've already rejuvenated the major questions doctrine. And this may be beyond those of you who haven't taken administrative law, but it sounds like, Alex, you've done a little bit of this. Basically what the court, and I'll put this in simple terms, what the court is starting to do is say, you know what, Congress, you got to get off your butt. You've got to start being more specific in what you want agencies to do. You can't just say, law enforcement, go out and prevent crime. You've got to be more specific. Well, in what ways? And what kinds of crime? In other words, what harms and what means and what targets? The states, by the way, are already starting to do this. The states have been doing this for years. Some state courts have put much more of a limitation on agencies, and they've required legislation to be much more specific in delegating their authority. If you haven't taken administrative law, what the non-delegation doctrine basically says is legislatures should not delegate all of their authority to administrative agencies unless they're specific about how they're delegating it. They shouldn't just go out there and say, go out there and do good things, right? And that makes sense, right? You shouldn't give it to executive body total power. And this court is, I think, going to reinforce that idea. That's what you're referring to, right, Alex? That's what you're getting at? Yeah. So yes, it's good for me. It might not be good for my colleagues down the hallway who teach environmental law and food and drug law, but I've been arguing this for now about 10 years. And I always talk to them and say, you know what? It might not be so bad in my area if the court goes the way it looks like it's going. Because the police are an agency too. And I'll say one last thing about that. One thing I've pointed out is scholars who write about the Administrative Procedure Act, what they will say is APAs apply to every agency in the federal government except for the police. Where did that come from? That makes no sense. Police agencies are agencies. There's one other exception, national security. You know where it comes from. It's, oh, we're protecting ourselves, so we can't have procedure acts get in the way. But there's nothing in the APA that says that. So, obviously, that question got me going. Yeah.
I did too. I'm administrative law nerd. I haven't taken the class. A lot of outside research on it, but I find it fascinating, and especially with the jurisprudence going. But I appreciate your answer a whole lot.
Any other comments?
Kimberly, Ahmed, anything?
This is really not my area of expertise or research, so I definitely don't have the very niche questions. I do want to thank you, though, Christopher, for taking the time out. I know it's your Friday, so thank you for sacrificing a little bit. It was a very insightful, and I learned a whole lot, so thank you.
Well, good. I'm glad to hear it. And have a good time in the rest of the seminar. I get to have several more classes. Is that right, Jessalyn?
Yeah, we have two more. So our
Okay.
remaining sessions, we will have Marcia Thompson, who will be talking about legal and ethical considerations in social media surveillance. So diving a little bit with a bit more depth into some of the topics you've touched on today. And then on April 19th, we'll have Jared Fishman from the Justice Innovation Lab. We'll talk about forecasting the future of algorithms and AI in the legal system.
Yeah, so that is social media is a very interesting issue because it's semi-public, right? A lot of it's, and so exactly how intrusive is it when police go in to access social media? At the same time, my surveys show, not surprisingly, people think of it as more private than public records, for instance. And as to the future of AI, who the hell knows? I mean, police are starting to get in on the act, but to tell you the truth, right now, none of the profiles I'm seeing the police or any criminal agency use are using sophisticated AI. It's all very primitive. And I'm not sure how sophisticated it's going to get ever. But in any event, I think it should be transparent if and when they do start using it. So.
I wholly agree, but thank you so much, Chris, again, to reiterate. Oh, sorry, Kimberly. Yes.
I just had, like, out of curiosity, just a personal question. What was the biggest challenge that you faced publishing virtual searches specifically?
Well, I guess it was writing it. That was a big challenge. Because things change every day. In fact, I wrote something about this in I published a book with the University of Chicago Press, which the cover's okay, but I like this one better. 2007, which is basically about the same stuff. But in my preface, I say, but everything's changed, right? Technology, a lot more technology out there than when I wrote in 2007. The courts changed. Those cases, Jones and Carpenter, they've changed things. And the public attitude is different because of back when I wrote the Chicago book, it was 9/11. And everybody said, hey, do whatever you want, government, protect us from these terrorists. But since then, Edward Snowden. So a totally different mindset. So those are three big changes. And among other reasons, that's why I felt like I needed to read the book. Write the book rather. And then the other challenge was just making sure I got things accurately, because again, the change was happening so rapidly. On things like profiling, I think I had to get updated. I was adding to the profile chapter the week before the final proofs.
That's good. I love that.
Because profiling is based on data. It's based on empirical work. And face it, you lawyers have to learn. You're going to have to learn about empirical research because it's influencing everything now. AI will definitely be influencing law, and that requires some knowledge of empirics. Yeah.
Interesting. Well, thank you.
Well, thank you for being an attentive audience, and
Yes.
have a good rest of the semester.
Thank you so much. Thank you for being with us. Thank you for sharing your energy and expertise with us. It was a really valuable session. Ahmed, Alex, Kimberly, thank you for being here, for contributing to this conversation. I attempted to upload our last session to YouTube. Well, I'm sorry, I'm currently on travel and was unable to. So I will certainly upload the previous ShotSpotter presentation as well as this one on my return next week. So in the meantime, keep up with your studies. For those who are celebrating Easter this weekend, I hope it is a meaningful celebration. For those who continue to observe Ramadan, may it be a meaningful fast for you. And in general, I guess, enjoy the continuation of spring. Again, I'm in a different country right now, so I have no idea what season or holidays are happening. But may you be healthy and happy, and I look forward to seeing you all next week. All right, be well, everyone. We'll talk to you soon.
Thank you.
Thank you.
Cheers.
Thank you.